court is not going to consider everything that is purchased from a child, but the court does consider those things that, sorry. Okay. That the court doesn't consider every purchase. They don't care if you buy clothes or chips or carrots versus ice cream, but those things that assist the child with those educational needs, the medical needs, the trajectory of their education 529 plans, that these are considerations that the court will consider for high net worth, right, individuals. Additional considerations that are a part of the child support conversation, and we do curate our settlement and negotiations to ensure that how you want your child to be supported and the financial support and the things that are important to you are considered as a part of a child support. Does that make sense?
The only way I can see that that's true. The only way I can see that that's true are situations where, like I've had a situation where they agreed that they weren't going to pay child support because dad was going to be in charge of like extracurriculars, medical bills, basically all of their expenses. So they didn't want child support. That's one situation.
And that stopped with the new law.
Yeah. Yeah. Well, yeah. That
you can't waive child support by paying
reserve
expenses.
it though. Like you can't. You agree neither of us pay the other.
No, they just stopped it.
You have to. So I'm trying to guess. I'm trying to think of when that's true.
So when we have above the guidelines.
But you're saying to tell them when we can go below the guidelines. Deviating downwards.
I agree with you that what I was thinking about has changed. So we can talk about it in reference to above the guidelines, not down.
There's circumstances when a court may deviate upwards or
Okay.
the parties by agreement.
In conversations where it's an above the guidelines child support case, there are instances where you can ensure that the funds that you are spending on a child go towards the needs that are important to you. But even with the child support, right, you can do a downward deviation. It just can't be zero.
Yeah.
Right.
You could say, yeah, we agree at $1.
It can be
Just so
zero.
that it's not zero.
Mm-hmm.
It can be zero.
You can
downward do it to
what is
zero.
that called? What is that term?
Reserve.
No, what is that term?
General.
Yeah, generally discharged. If it's like nothing.
So what happened with Smith?
We couldn't downward deviate because the actual number was like 1,800. It was too high
that's
to
too high.
deviate.
You can't do that if it's too high. If
Yeah,
it's
it was
like
too high. We couldn't deviate down.
$200 or less.
Yeah.
Then you could say we're going to just generally discharge.
I mean, I had a case where the child support came out to zero with the calculator without a deviation, so that's possible.
Yeah.
If they have exactly the same income and they have joint, then
So maybe I'm talking specifically about the downward deviation, not necessarily getting it to zero, but making sure that the funds that you are giving to the child, we can curate or ask for those things to go directly to those needs.
But the only time you can do that is if you have an MSA that says that, right? Is that what you're talking about? Because a judge is not going to. We can't.
So
the
I've
only time
had
that I
like
can
a
see that.
few
The
instances
judge ever
where
going to downward deviate by absent an agreement?
like
What
say
would
for
you
instance, a
need to-
child is in private school and they've been in private school and they want to take them out of private school. A judge may say that the status quo should be there and that should be a credit.
And
But
he
that'll
doesn't-
be factored into the extra the
Child
additional
support guidelines.
expense. Yeah,
Yeah.
so you wouldn't need to
But
make
it
like a
reduces- it reduces your
separate.
child support.
Yeah, it
So
does.
the
It
biggest thing
reduces.
that a lot of clients are upset about is that money is going to this person.
Yeah, but that's what I think we're getting there. I'm trying to say it is going to that person. You have no say where that goes,
Yeah,
unless you have
and
an
that's what I was
agreement that says, okay, we're
to be
both going to put this
spent
in for.
on
That's exactly
room
right.
for-
They are exactly
There's like
right.
a presumption.
So if there are
of what
expenses,
are supposed to be.
because this, I mean, see, it's the Wild Wild West, right? Prince George's County up there. So I gotta also remember where are we, and we're talking generally too. But it's that argument that there's a status quo of things that are being spent, and I want to make sure that those things are still being spent on the child.
That's going to be up to the discretion of the judge.
Right.
But I rarely do. Was that? I mean, unless yeah. I
Is that
mean, I
what
guess
you-
if the kids has always been in private school and he's 12 years old, he's got like 6 more years, then yeah, that's something you could argue for sure. But it's
Yeah.
not guaranteed
But that
Yeah.
would also
Yeah.
be already, it would already be factored into the number.
into the child support number, exactly.
Sometimes.
Unless there's agreement
Yeah,
that
no,
says
the-
dad will continue to provide for child support tuition payment, or sorry, dad will continue to provide child tuition payments.
That's the point.
That's in an agreement.
What are we talking about though?
I don't disagree with
I-
you
I
that there's
know,
some that because the majority of
I'm like watching
counties
the tennis ball
aren't
go
doing
back and
that.
forth.
Yeah.
that
I
it's
think
not
because
a
we're being
general-
lawyers,
I
honestly.
don't
We're just having
disagree.
lawyery talks.
I can't. I think what
Yeah,
Pat's
like-
saying is like she's talking about the likelihood of that being across the board, and I'm saying that it's a possibility.
I don't even think
And
we
I
should
don't-
put that in the video though. Like I feel like this is
I don't.
what I said earlier about you can deviate if it's in the best interest. Like let them come to us to find out the rest. Like I don't know if we should. You know, I thought we got a little off track.
I mean, we can say all that, there are circumstances when
Where
a
could
court would
deviate
deviate,
upwards or downwards? Yeah. I
but
don't.
the presumption is that the support is going to be utilized. on this.
Yeah, because it's math. The numbers are going to be what the numbers are going to be.
Mhm.
Unless you could show someone who just misused.
Okay. All right, so that was custody. That was child support. Did we talk about alimony?
No, we did
Mhm.
not.
Alimony. What are the biggest considerations or issues that a client can overcome when it comes to alimony in a divorce case?
I think one of the biggest considerations in alimony is the income of the parties. The income of the parties, the length of the marriage, the lifestyle of the parties as well.
Absolutely. When I speak with clients, obtain initial information, these are some of the questions I ask. Length of the marriage, rough incomes of both parties, because right then and there I have an idea that I can speak with the client about in terms of, do I think this is an alimony case? Do I think that if we represent a possible recipient, would he or she be entitled to something? If we represent the payor, would he or she be likely to have to pay X amount of money? So we certainly use our initial intake meetings to ascertain relevant information that we could have a further conversation with the client about. But those are two of the big ticket items in determining whether or not alimony is going to be a relevant consideration in your case.
And what my colleagues are describing are the alimony factors that the court actually looks at. There's 11 of them. And in those factors, like my colleagues have mentioned, how the marriage even broke down, the status quo during the marriage, those things do matter. But in the grander scheme of things, also, the court also has to determine if it's going to be rehabilitative or indefinite if it is awarded. Rehabilitative alimony is for a temporary amount of time so that you or whomever is requesting it can learn a new trade or learn a new area that would allow them to be gainfully employed in a new way, in a better way for the future. Indefinite alimony is just as it sounds, indefinite. Now, it is modifiable by law if you can show a material change in circumstances, but indefinite alimony can be granted if, like my colleague mentioned, if the disparity between the incomes is so great. If you're making 5 times more than your spouse, you do have some exposure there for indefinite alimony.
Alimony, custody, child support. Let's talk a little bit about marital property in the essence of property that you had before your marriage versus property you have now, and more so over how do we come to a settlement or negotiation? Isn't it that number is that number and everything should just be split in half? Why is it that there is an entire process when it comes to marital property instead of just
Do that one.
splitting it?
It's Walters.
Talk about it.
Okay, so when we're talking about marital property, the one of the biggest questions is determining whether it's non-marital or marital. To keep things simple, in layman's terms, non-marital property is property that was established prior to your marriage. Marital property is determined the property that has been obtained and accrued since the day of the marriage until the present time, and here we are now. If we're talking about in terms of a home or retirement, you're always going to be entitled to your marital share or your equitable share. And the way that we determine that is finding out what the value of the property was at the time of the marriage and what it is now. How much it was accrued, and then splitting that in half will determine what your marital share is. Anything that was accrued prior to your marriage remains sole property and non marital property.
Unless there's commingling involved.
Mhm.
What is commingling? Commingling is when you have a non-marital source, like my colleague mentioned. If you have a bank account that was opened before your marriage, and you put in marital assets, meaning after you get married, money that you and your spouse has earned is commingled and merged with that money, it is no longer just non-marital. It becomes partially non-marital. Another way for something to be non-marital is if it's by inheritance. If somebody leaves them something in a will, that can't be touched by the other party because that's an inheritance that only belongs to the person who's receiving the money or whatever it is.
One thing that is important to note is sort of how these courts determine what's quote unquote fair. The way that they do so, the terminology is they try to divide up estates in an equitable manner, meaning under the circumstances of any given case, what the court would think to be fair. Sometimes that means a clean 50-50 division of everything down the middle. Other times it doesn't, and it's a little lopsided. So for instance, to sort of tie it back into what Asia was discussing, equitable in a circumstance may mean that one party walks away with the majority of the marital estate because the other party perhaps had, certain non-marital assets. In totality, they're both left perfectly fine at the end of this, but by dividing it up in quote unquote inequitable manner, it's actually making it a fair resolution. So equitable is sort of the important term that the court looks at in determining whether something is fair.
Another important consideration that the court will look at when it comes to what is equitable is the length of the marriage. Sometimes if this is a marriage that is ending after 30 years or 20 years, that's going to mean that the likelihood is the majority of marital property is going to be split right down the middle for good reason. The courts understand that it took a lifetime to build the home and the marital estate, and you did it together. Now, if a marriage is a lot less length in time, say 2 or 3 years, and there's a lot of marital property, it's less likely that the assets will be divided straight down the middle. It's more likely that they're going to be divided based upon what financial contributions each party had to each asset.
I think too, to kind of tie this all back into like settlement, I often tell my clients to pick what hill you want to die on, right? If it comes to a asset or something that you know that you just don't want to be bothered with, like for instance for a vehicle. If you have a vehicle and he has a vehicle and it was both purchased during the marriage, do you want to make them sell their vehicle to split the proceeds? Do you want your vehicle to be sold and split the proceeds? And sometimes it's just easier to decide what is worth your peace of mind in terms of marital assets.
One last thing based on that, within the context of a quote unquote settlement too, I think that what Asia was touching upon is very relevant. What's important to me might not be important to Monique or to Paula. And so there's a little bit of an individual component that plays into it. I may think that something is more important than my spouse, or have more interest in something that my spouse might, vice versa. You can sort of play these things off one another, even if they are things of different value. I may think something may have more sentimental value to me than it does to the other person. So when we talk about what's quote unquote equitable, I think it's important to sort of put a caveat in there that there's a number of different considerations that go into that determination. Part of our job is to help you sort of navigate that mindset.
And I think too, the marital assets don't just have to be your big ticket items. They also include the furniture in your home, the couch set, the dining room set, so on and so forth. The vacuum cleaner. I've seen where clients have gotten really down and detailed, into specific personal items that they would like, and then in other instances, some clients are like, I don't want it, he can have it, and it's a very clean break. So just something to keep in mind as well.
I'm laughing because I had a case where they were fighting over a bouncy castle.
Yeah,
They were both
yeah.
grown adults with no kids, but they were arguing over the bouncy castle.
Yeah, in my case,
You
they
have
were
it.
fighting over the patio furniture.
Plates,
Yeah.
fans.
Like, but they don't
Cushions.
have any children. Like, their children are like 40 years old. Like, it was weird.
All right, guys, I am satisfied. Do you guys have anything, last thoughts?
Heavy side.
We're gonna. You said that one of the videos is definitely gonna be the like our
About
introduction. Okay, can I do my introduction again then?
Yeah.
Thanks. That's it. That's the only thing I wanted.
All right. You want to do it sit down? You want to do it up there?
I can do it.
Okay.
You want us to step away?
So now y'all can definitely.
Yeah.
Yeah.
Disperse.
I don't think mine was good.
Solo shot.
Can I do one thing?
But
You
the
mind
others
if I
are all
touch you?
Oh,
together,
no,
right?
not at all.
Oh yeah, we were. The first one we
So
were all
then they have
together.
to be together
Thank
now.
you.
Well, this is
No,
an
no, this is
individual
for
shot.
intro. For so each,
Oh, this is for,
on the website,
okay.
they all have an about us page,
Oh,
and so this is going on her about us page, and so we all can do an about us video.
Okay.
That's not what we did the first time.
She's doing it
I'm just
again.
doing
Oh,
so
okay.
if you want to,
Mine went
you can.
Anyway. I'm Paola Rodriguez. I'm an attorney that's been practicing here in Maryland for almost 13 years. My goal is to work with families that are navigating the space of a divorce. This is a very complicated time in everyone's lives, and we're here to help you. It's important to me that each of my clients understands the entire process from beginning to finish, and that we can continue to stay in regular communication as new aspects approach.
As new aspects of your case.
As new aspects of your case. Sorry, let me do that again. As new aspects of your case develop.
Are you gonna say call us today or?
You don't have to on that one.
Okay.
You don't have to on this. This
Okay.
is like
Okay.
this is about us.
No, that was good, Paola.
And by the way, that
Yeah.
was okay at first.
Anybody else?
No.
Okay.
No.
You got better too. You started thinking about it.
Yeah. Just got into the groove.
Yeah, you started talking.
Yeah.